5 seconds. We are absolutely conscious that in the case at hand the seniority has not been disturbed in the promotional cadre and no promotions may be unsettled. There may not be unsettlement of the settled position but a pregnant one. The respondents chose to sleep like RIP Van Winkle and got up from their slumber at their own leisure for some reason which is fathomable to them only. But such fathoming of reasons by oneself is not countenanced in law. Anyone who sleeps over his right is bound to suffer. As we perceive, neither the tribunal nor the High Court has appreciated these aspects in proper perspective and proceeded on the basis that a junior was Varinder Singh 2014 11 25 11 25. I attest to the accuracy and integrity of this document. Punjab and Haryana High Court at Chandigarh promoted and therefore the senior cannot be denied the promotion. Remaining obvious to the factum of delay and laches and granting relief is contrary to all settled principles and even would not remotely attract the concept of discretion. We may hasten to add that the same may not be applicable in all circumstances where certain categories of fundamental rights are infringed, but a stale claim of getting promotional benefits definitely should not have been entertained by the tribunal and accepted by the High Court. True, it is notional promotional benefits have been granted, but the same is likely to affect the state exchequer regard being had to the fixation of pay and the pension. These aspects have not been taken into consideration. What is urged before us by the learned counsel for the respondents is that they should have been equally treated with Madhav Singh Tadgai, but equality has to be claimed at the right juncture and not after expiry of 2 decades. Not for nothing it has been said that everything may stop but not the time, for all are in a way slaves of time. There may not be any provision providing for limitation, but a grievance relating to promotion cannot be given a new lease of life at any point of time. Emphasis supplied further in Civil Appeal number 1941 of 2014 arising out of SLPC number 15530 of 2013, Chennai Metropolitan Water Supply and Sewerage Board and others versus T.T. Murli Babu, decided on 10/2/2014, considering the issue of delay and laches. Honorable the Supreme Court opined as under first we shall deal with the facet of delay in Maharashtra State Road Transport Corporation versus Balwant Regular Motor Service Amravati and others. AIR 1969 SC 329. The court referred to the principle that has been stated by Sir Barnes Peacock in Lindsay Petroleum Co. versus Prosper Virendra Singh 2014 1125 1125 I attached to the accuracy and integrity of this document. Punjab and Haryana High Court at Chandigarh Armstrong Hard Abraham Farewell and John Kimp 1874 5 PC 221, which is as follows: in State of Maharashtra versus Digambar 1995 for SSC 683, while dealing with exercise of power of the High Court under Article 226 of the Constitution, the court observed that power of the High Court to be exercised under Article 226 of the Constitution. If is discretionary, its exercise must be judicious and reasonable, admits of no controversy. It is for that reason a person's entitlement for relief from a high court under Article 226 of the Constitution, be it against the state or anybody else, even if is founded on the allegation of infringement of his legal right, has to necessarily depend upon unblameworthy conduct. Virendra Singh 2014 1125 1125 I attached to the accuracy and integrity of this document. Punjab and Haryana High Court at Chandigarh of the person seeking relief, and the court refuses to grant the discretionary relief to such person in exercise of such power when he approaches it with unclean hands or blameworthy conduct. Emphasis supplied in Bal Krishna versus State of Punjab and others 2013 RSJ 18, wherein the petitioner, after rendering about 34 years of service, sought refixation of his pay from the date he joined service by filing a petition more than 3 years after his retirement. The court dismissed the writ petition on account of delay and laches only. Virendra Singh 2014 1125 1125 I attached to the accuracy and integrity of this document. Punjab and Haryana High Court at Chandigarh. Similar view was expressed by the court in CWP number 13965 of 2010, Tarsem Pal versus Punjab State Power Corporation Limited and others, decided on 29/11/2012, CWP number 3124 of 2011, Harnam Singh versus State of Punjab and others, decided on 10/3/2014, and CWP number 28508 of 2013, Suraj Mal versus the State of Haryana and others, decide on 29/9/2014.